Welcome, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and today I'm starting the Essentials course for the MBE for the February 2026 bar exam. And I had to think about that because I always like to timestamp my classes, and I've been doing this for a long time. The MBE is a tough test, but it's one question at a time. So I'm going to start with a lecture where I just kind of talk about some of the most important concepts that I can recall from the MBE contracts and torts, and then I'll follow up by going over the PowerPoint quickly that's included so you can see some of the visuals and, kind of make heads or tails of things. Encourage you all to do practice questions, practice questions, practice questions, and I include in the chat the master cram guide, which is a great place to start memorizing those points and also to model your own study after. Do practice questions. If you get them wrong, write the fact or the pattern or whatever it is that'll help you get that type of question right the next time. I encourage everyone to, by test day, be getting all the questions right, right? Just based on repetition, familiarity, and the fact that you've really mastered the material. All right, so I'm going to start with contracts, and contracts I think is an easy essay subject. You can just kind of remember all the key buzzwords and then write it out on your essay and get a lot of points. I think it's a very difficult MBE topic because they test a lot of nuances and they can really trick you on the questions, right? So, the first thing that we're considering when it comes to contracts is the body of law, the governing body of law, right? There's the UCC, which will govern if it's goods, which are, all things movable, and then common law will govern if it's going to be land or services, right? That'll be under the common law. And there's some differences between common law and UCC that are important to take note of. One of them that's heavily tested is this idea of a modification. And if I say something insightful, I encourage you to write it down. Try to learn as much as you can today from this lecture. But talking about a modification, just to see if anyone's awake or alive or has any pulse in the class, does anyone remember the difference between a modification under the UCC and a modification at common law? What's the main difference between that? If we have a contract and we want to modify it, what do we need at common law that we don't necessarily need under the UCC? Someone in the chat.
Consideration.
Yeah,
Consideration.
consideration,
Versus good
consideration.
faith.
Yeah, exactly. You're going to need consideration at common law. You only need good faith under the UCC, but MB is a tough test. Is there a time when you would still enforce a modification at common law without consideration? There's specific language when you would, right? The answer is going to be if it's fair and equitable under the circumstances and it's to remedy an unanticipated change at the time the contract was formed, right? So, if, right, it's fair and equitable under the circumstances and it's to fix something that neither party could have anticipated at the time the contract was formed, then we will enforce that modification without consideration. So, I like to just give that example to start to show people that like the MBE is not so much of a minimum competency test as they make you think. It's like you need to know the law and then you also need to know an exception. So that's the first thing that we talked about today is modifications require consideration at common law, just good faith under the UCC, but we will enforce a modification at common law if it's fair and equitable under the circumstances and it's to remedy an event that was unforeseeable at the time of contract formation. That's a solid distinction between common law and the UCC. What about when it comes to actual formation of the contract, when we have the offer and the acceptance? Does anyone remember the difference between common law and UCC when it comes to forming a contract, right? The terms of the acceptance. Which one do you need the mirror image? Mirror image for common law, right? Great, Melissa. Great, Ivana. A common law, you need the mirror image, which means the terms of the acceptance need to match the terms of the offer exactly. Like, I do tutoring, that's a service. So if I pick up the phone and Tommy says, Andrew, will you tutor me for $500 an hour on Tuesdays? And I say, yes, but it actually needs to be on Thursdays, right? That would not be an acceptance because I have added an additional term. So there's no mirror image. So at common law, we need the acceptance to match the offer exactly. Where under the UCC, we have a different set of rules. It's the additional terms test, right? So if there is an additional term and it's not material, it's immaterial, then there will still be a contract, right? And the new term will be included in the contract unless the offerer expressly rejects, usually within a reasonable time period, like 10 days. So that's that concept of the additional term. If there's, UCC and it's over widgets and they say, will you sell me 100 widgets for $5 a widget? And the acceptance says yes, but delivery will be delayed by 2 days or something, then that's most likely going to be a completed contract and the additional term will be included because it's not material. Now, what if the additional term is material? What if it really is something like a mandatory arbitration, which that jurisdiction deems to be material or whatever it may be? It's going to be exactly what Melissa's saying. If the conflicting terms are material, then we're going to incorporate the knockout rule, which means that additional term will be knocked out. And then what term do you use? The term that was in the offer, the term that was in the acceptance? They were conflicting. The answer is going to be these UCC gap fillers, right? Right. Whatever the UCC says under the circumstances, they'll fill in that gap. So remember, common law versus UCC. Common law, we have the mirror image test, where under the UCC, we have the battle of the forms provision where an additional term will be included in the contract so long as it's not material or the offerer expressly rejects. And if it is material, there's still going to be a contract. It's just that additional term is going to be knocked out and we're going to use the UCC gap fillers. So at formation, common law versus UCC, we see that common law has the mirror image test, but the UCC has the additional terms test. So it's kind of like the common law is more strict, right? You need to have the exact terms in the acceptance. But what about when it comes to the execution of the contract? It's the other way around. Does anyone know the term for delivery of services or let's say delivery of goods under the UCC? They need to have a exact delivery. What do we call it? Exactly, unless you're on point tonight, right? The perfect tender rule. Perfect tender means that, if you order and agree to 100 red widgets and they deliver 98 red widgets, that's not a perfect tender. That's a breach of contract, right? I mean, the questions are tough because they say, hey, I have 98 widgets, two got damage in transit, but I'll follow up with them tomorrow. That's going to be okay. You do have a reasonable time to cure to make the tender perfect, but in general, you can't just be like, oh, I came close, so there's no real damages here. There's not a breach of contract. There is a breach of contract if there's what's called an unconforming shipment or non-conforming shipment. A good example, you guys will remember this when you do the that sample quiz, that NCB diagnostic quiz. There's a person who orders pictures of a golfer for their advertisement purposes. And they ordered it with a right-handed golfer. But then the pictures come and it's a left-handed golfer. And like it doesn't have any you know, it's not going to affect the value of it or anything. It's just the person wanted right-handed and got left-handed. So what's the result there? The result is that's a breach of contract for a non-conforming tender because it had to be a perfect tender and it wasn't. So that's kind of an example of when you're going to have that perfect tender rule come into play. Now, at common law, it's more of a substantial performance, right? Like if you mostly performed, you did your best to perform, then that's going to be considered, performance under the contract. You don't need to have that perfect tender. So I like to think of it as the UCC is more strict when it comes to contract execution, whereas the common law is more strict when it comes to contract formation. So those are, some main things to remember when we're considering differences between the UCC and for common law. So one thing that's heavily tested on the MBE when it comes to contracts is defenses to contract formation and execution. A main one, of course, being the statute of frauds, right? You got to remember when is it necessary that a contract must be in writing, and you can kind of remember that famous mnemonic, which is my legs. contracts in consideration of marriage, contracts that cannot be completed with 1 year, contracts for land, executorships, and goods over $500. So, yeah, if there's a contract to get married, then it has to be in writing, or it didn't really it's voidable, right? It's not, it doesn't conform with the statute of frauds provision. Contracts that can be completed within 1 year, contracts that cannot be completed within 1 year. They like to test a little tricky nuance to this question. So I agree to tutor Kim Kardashian. She's about to get her results out from California bar. If she falls short, please someone send her my number. But Kim Kardashian, I agree to tutor her for the legal studies for the rest of her life. Does that contract need to be in writing? It's for the rest of her life. She's spring chicken, right? I don't know. She's dating like she is. She's a young person. So she's probably going to live for over a year. But it doesn't need to be in writing. Why? Because it's contracts that cannot be completed within 1 year. It could be completed, right? If tragedy were to strike the Kardashian household and she didn't live over 1 year, then I could potentially tutor her for under 1 year. Yeah, someone's asked me to explain that one more time. So the contracts that cannot be completed within 1 year. Remember, law is all about this precise language, especially contracts. That means that there's no way the contract could be completed within 1 year. So if I say I agree to tutor Kim Kardashian for the next 3 years, that contract must be in writing. If I say I agree to tutor Kim Kardashian for the rest of her life, that contract does not need to be in writing because it could be completed within 1 year. The rest of her life could, as a matter of fact, be less than 1 year. So it's very specific about could it be completed within 1 year or not. If it's for 3 years, there's no way that I could complete it within 1 year. If it's for the rest of her life, then that wouldn't need to be in writing because of the precise language of the concept, right? Contracts for marriage, contracts that cannot be completed with 1 year, contracts for land. They definitely need to be in writing. Every parcel is unique, and it could give rise to we'll see this in property, but to specific performance, right? Where they agreed to the contract, so they're gonna get that piece of land. But that also does need to be in writing. Executorships, that means like if you're going to have the power to contract on someone's behalf, maybe a guardianship or a living will or a durable power of attorney. Something of that nature needs to be in writing. Um, Goods over $500, right? It's pretty self-explanatory, but be careful because there are some questions where they're like, Tommy agrees to a piece of jewelry for $1,000 and it's delivered. So would that be an exception to the statute of frauds? Not if it's not accepted. They have to actually accept the delivery. And then you could say, okay, partial performance or some detrimental reliance theory. But if it's only delivered and not accepted, then there's no contract. They don't have to accept it because it wasn't in writing and the goods were over $500. And then that concept of surety ships means, you know, um, a third party that is signing on someone's behalf, or that's paying the debt of another or something, like a third party who's taking on their obligations. That agreement would need to be in writing. Yeah, so there's definitely, importance to the language that you need to look at, but that's contracts that must conform with the statute of frauds. I have a good mnemonic for remembering some exceptions when it seems like it has to be in writing, but it actually doesn't, like specially manufactured goods. The mnemonic is SWAP, SWAPP, and that stands for specially manufactured goods. Like if that piece of jewelry was for Andrew and it said Andrew with like my birth date on it or something. Well, even though it wasn't in writing, it was specially manufactured, so it's okay that it was oral or the written confirmatory memo. The way they test this, the written confirmatory memo is, two merchants agree to, you know, I- Tommy calls Johnny on the phone and says he'll sell goods for $1,000 and they're widgets. They're blue widgets for $1,000. Okay. But it's oral, its goods are $500, so there's no contract, right? But then the facts say that Johnny, 3 days later, sends a confirmatory email that says, this email is to confirm the, 500 red widgets for $5 a widget, right? Well, that is going to be an exception to the statute of frauds. The contract will exist based on the confirmatory memo, so long as it has the essential terms, right? The UCC essential terms. It doesn't include price, but it will include, quantity and description of the goods. So what's enforceable if there's a conflict between the confirmatory memo and the original oral conversation, it's going to be the terms of the confirmatory memo. If the person, the other side doesn't object to it, that's going to be the written contract right there. So that's the written confirmatory memo. Look for a way that we can enforce a oral contract if there's a subsequent written confirmatory memo. Admission in court, right? If they admit in court that a contract existed, then even if it wasn't in writing, it'll be enforceable. And then theories of promissory estoppel, which will associate with detrimental reliance and partial performance, right? Like if they've already completed the work, right? And it was supposed to be, or completed the delivery and it was accepted, right? Delivery plus acceptance, or in land, it's usually at least two of the three, payment and improvement and possession. If those elements are met, then they could argue for partial performance. So, that's a, a good way to start thinking about the statute of frauds and what contracts it applies to. And then when we have exceptions where even though it wasn't in writing, it's still going to be enforceable because, like I said, especially manufactured good or written confirmatory memo or partial performance, one of those different theories. And I'm trying to just make y'all understand some of the heavily tested things today. So another defense, I mean, there could be fraud, duress, misrepresentation, concealment. That's usually, if there's bad faith, if one party just was misrepresented, they didn't tell them about something that was material, that's going to be a solid defense, and we're going to be able to um, get out of the contract. But what's the difference, does anyone know, between duress and undue influence? Because I've seen this one tested a few times. Does anyone remember the difference between duress and undue influence? Yeah, like what Ivani is saying, the relationship, right? Undue influence is when one party, abuses a position of power. It's related to, the caretaker and the elderly woman, and on her deathbed, they switch the inheritance, right? That would be undue influence, where, yeah, it requires a special relationship between the parties. Whereas duress is a threat, right? That's like holding someone at knife point and getting them to sign the contract, right? So, that's a key point. There's also like unconscionability, right? Substantive or procedural unconscionability. When you think of unconscionability, just think like the terms are so unfair. Um, you know, $1 million for a bottle of water, right? Because they're in the desert or something. That would be substantively unconscionable because of the terms of the agreement. So those are some, important defenses to contract formation. And then defenses to execution, you could think of like impossibility, impracticability, or frustration of purpose, right? For impossibility to hold, it really does need to be impossible. It's not extremely difficult. That would be a better claim for impracticality, but impossibility means there's no way that the contract could be performed. Some key terms that I think are heavily tested when it comes to contracts on the MBE, anticipatory repudiation and parole evidence. And how are they tested? So, anticipatory repudiation is when one party unequivocally demonstrates an intent not to honor the obligations of the contract. What that means is, you know, A calls up B and is like, hey, I'm not sending you these widgets. Like, sorry, we're just not going to have them in time. Nothing I can do about it, and hangs up. Well, that's going to constitute an anticipatory repudiation. So then the other party, could seek alternatives, and they can try to, rectify the fact that they're not going to receive the benefit of the bargain. If the one party has, you know, reasonable insecurities that the other party is not going to perform, they could send what's known as a request for further assurances, which needs to be reasonable, but then they could pretty much sniff out and say this person's not going to perform. So that constitutes an anticipatory repudiation, which is either a present breach or they can wait until the actual repudiation occurs and then sue for breach then. Um, so I'm not going to deliver you the widgets based on our contract unless I'm legally obligated to do so. Is that an anticipatory repudiation? The answer there is no, because that statement, that qualifying statement, unless I'm legally obligated to do so, well, that means that you will, because you are legally obligated to do so, because you have a contract that's obligating you to do that. So remember, it does have to be clear and unequivocal if we're going to determine that there's been an anticipatory repudiation. Yeah, and someone saying they got that question wrong, they'll never forget it. I mean, that's pretty much the nature of my MBE business, right? I've just done all these questions so many times that like, especially the ones that, students have gotten wrong, they stick out to me. And then I just try to like, smooth them out because y'all are not that different from each other. You tend to get a lot of the same questions wrong and for the same reasons, right? And then parole evidence. So parole evidence is definitely heavily tested. It's this concept that we're not going to allow extraneous evidence to contradict a fully integrated contract. So, two parties are agreeing to, widgets for a certain price, and they have all these oral conversations where they throw out different price terms and things, but then they sign a contract. We're going to look at the four corners of the contract to determine whether what the price is and what the obligations are. You're not going to be able to use these oral conversations to contradict the terms of the contract because, we reduced this to writing for a reason. But they do test the exceptions to the parole evidence rule. Does anyone remember any times where we're going to allow parole evidence where it will be admissible?
When there's an ambiguity.
Yeah, that's a very common one when there's an ambiguity to clarify ambiguous terms, like um, two parties agree to a handful of snacks. Well, are we talking about, Victor Wembanyama's hand, or are we talking about like Mini Me from Austin Powers' hand, right? That's kind of ambiguous. So we can say like, oh, in the industry, right, custom trade and usage, the hand is like a normal sized hand, right? Like something that would clarify these ambiguous terms. Or there's one question I can think of where it's like, um, someone signs and then they put under it president. Well, is it that they were signing individually as the president, or were they signing on behalf of the company? We could bring in parole evidence to show that it was meant to be on behalf of the company, right? To clarify ambiguous terms for sure. Another one that's super heavily tested is a condition to contract, right? I agreed to tutor Susie. Susie took the Florida bar but split it up, and I said, "Yeah, I'll tutor you for the MBE at this price if you pass Florida, right?" And then, Susie doesn't pass Florida, and we reduced it to writing and just said, "I agree to tutor you for the MBE." But then I'm like, "Wait a minute, there was a condition. I would only do that if you had passed the first part." And she's like, "Oh, well, that's not in the written contract, so we can't include it." We can include it because it's a condition to contract. So that's pretty heavily tested exception to the pro evidence rule. If it's a condition to contract, if it's to clarify ambiguous terms, if it's to show custom trader usage, if it's to show a defect in formation, like there was threat or duress or some reason why the contract wasn't properly formed, or to show an additional term. Like this question, a lot of students get wrong. It's like about horses, right? And it's like there's a agreement to have a gray horse, and it's going to come with a saddle, right? So then they reduce it to writing and they say it's a black horse, and they don't mention whether it comes with a saddle. Can you bring in evidence to show that it was a gray horse with the oral conversation? No, because that would contradict what was written, right? You say gray, but we wrote black. We're going to go with black. Now, can we bring in the additional term that I was supposed to come with the saddle? Yes, that we can, because it's not going to conflict the fully integrated contract. It's just coming in as an additional term. So, parole evidence is a good one to work with, right? I'm trying to give you guys some key points here. Parole evidence, anticipatory repudiation. Um, you know, when you think of contracts, you really want to think of damages, because what's the point of suing if you're not going to have some relief, right? So there's expectation damages, and that's typically the best measure of damages to put the non-breaching party in the position they would have been if the contract had been performed, right? So, um, you know, there's a duty to mitigate too. You can't just sit on your hands and not mitigate damages, but like with mitigation, what would you have received? So there's a contract with a teacher for $50,000 to teach math, right? And then the day before, the print or the school is like, hey, sorry, offer's no longer available. Well, what's she gonna do? She's gonna sue, right? How much can she get? Well, assuming there's no other jobs available and she doesn't take any other jobs, she can get the full $50,000, right? Because that's what she should have gotten. She was going to teach math. Now, let's say there's another job available as a gym teacher for $40,000. Well, people be like, oh, well, she got to take that job and it's only $10,000. That's not true. You don't have to take the gym teacher job. You're a math teacher, right? It's got to be a comparable job. Now, let's say there's another job for a math teacher for $40,000 and she doesn't take it. Well, can she get the full $50,000? No, she had a duty to mitigate. She had a duty to either take that job and get the $10,000 in between or not take that job and get the $10,000 in between. But her damages minus potential mitigation would be the $10,000. So long as it's a similar job in a, that's comparable. It wouldn't be some other job. So you don't necessarily have a duty to take the other job, but you can't be doubly enriched. Like you can't take the other job and then get paid the full 50,000. You're just going to be put in the position with proper mitigation if it was available that you would have been if the contract had been completed. That's expectation damages. They also have consequential and incidental damages. And the most important thing, like one thing that y'all can remember from today about consequential damages is they need to be foreseeable. Meaning like if, there's a property sale and it doesn't go on the date is closed and time was of the essence, they can get the rental value for the property. But if they were gonna like, raise cattle on it and make profits for 2 weeks, but the other party had no reason to know that they were gonna do this whole cattle operation, well, they weren't foreseeable. If they were foreseeable, then they could also get those additional damages as consequential damages. But a lot of this test comes down to terminology and matching, the right answer with the key word, right? So for consequential damages, the key word is definitely foreseeable. Consequential damages are recoverable when foreseeable. The last type of damages, I'll switch to torts because again, it's essentials course, just trying to give you guys some of the key points and then I'll go over to PowerPoints quickly to end. But the last thing would be this concept of restitution. Restitution is to disgorge ill-gotten gains, to take money away from a party that didn't deserve to get the money in the first place. The best example of restitution is, let's say I collected a deposit from everyone to come to my essentials course. You all gave me $100 to reserve a seat, right? And then it turned out I couldn't do the course, right? I had to go to France. And they don't have good internet there. So, see ya, not doing the course. Would it be fair for me to just keep all your deposits, even though I didn't do the course, I breached the contract, right? No, it wouldn't. There would be an act of restitution for you to disgorge those ill-gotten gains to prevent unjust enrichment and return the money back to you. That's the best way we can think of for restitution. And then I'll just mention, like, this word association, you typically associate promissory estoppel with detrimental reliance. Like one party relied to their detriment on a promise, so therefore, under theory of promissory estoppel, they'll be stopped, they'll be denied from, you know, failing to honor the obligations of the contract. So that's that concept of promissory estoppel. And then finally, I think the hardest part of contracts when it comes to MBE questions would be the idea of intended versus incidental beneficiaries, right? Intended beneficiaries could stand in the shoes of a party and enforce the obligations of the contract. And if they relied on those rights or they sue under those rights, then those rights have vested as well. An intended beneficiary is someone who's contemplated to benefit from the contract. Like if A and B agree to pay C $50 every month, and then C's getting paid $50 every month, C's an intended beneficiary. If B stops paying C, C could stand in the shoes of A or B and enforce those rights, right? Because they're intended to get paid. An incidental beneficiary is like, a neighbor is really excited because their neighbor has a contract to cut down these trees with a tree cutting company. And then the tree cutting company breaches the contract and doesn't cut them. And now the neighbor's like, well, now I'm not going to have this benefit of having all the sunlight on my property. So can they sue as an intended beneficiary of the contract? No, right? They're merely incidental, so they can't stand in the shoes of the either party to the contract. So, again, I'm going to bounce around today from contracts to torts. And I wanted to start by just getting the wheels turning, having people remember, oh, yeah, these are some of the main things I need to know about contracts. And like I said, I'll go over to PowerPoint a little bit at the end to show you these things. But yeah, that was my introduction to contracts, MBE. Hopefully, you learned some things. And if not, that's a good sign. These were all reinforced. With torts, I gotta say for me, I don't know why, but torts has always been my best subject. Like every bar exam I've taken, I've scored in the top percentile. I got the Cali Award at my school for I think one of the highest scores in torts. Like I swear I didn't even know what a tort was when I went to law school, and then it's just always been natural to me. And I think it's because I'm pretty reasonable, right? Like if there's a situation, you kind of look at both sides and be like, okay, what party was harmed here? How would we compensate them and make them whole? That's what we're trying to do with torts. It also comes down to just being able to identify the elements of the different claims of action, right? Most torts questions, or the majority, the highest most heavily tested topic would be negligence, of course, right? Negligence requires that duty, breach, causation, and damages. The duty is very interesting. Like, was a duty even owed? That right there is like the best defense to being liable for negligence. Like, I didn't even owe a duty. No duty was owed, right? Like, uh, there's no duty to trespassers, right? To known trespassers to warn, I'm sorry, to unknown trespassers. There's no duty that's owed to them to, have a warning sign. You didn't even know there would be people on the property. So how could you owe a duty? Therefore, you're not going to be liable for their injuries, right? Um, so, and then some types of dangers are open and obvious, right? Like the danger of falling off a ladder. There's no duty to warn people that you could fall off a ladder. It's open and obvious. Or barbed wire. There's no duty if there's barbed wire in the fence to be like, hey, this barbed wire is sharp and pointy. Make sure you don't get injured if you try to climb on it, right? It's an open and obvious danger, so there's no duty to warn. I remember I took, I think it was a California bar exam. There was one question that stumped me, and I don't like getting stumped, right? So I spent like way too long like thinking about this, and then I did three questions, and I went back to it. Like, don't let that happen on test day. If you get stumped, just pick C and move forward. It's not that big of a deal. But for me, I was pretty annoyed with this question, and I thought, you know what? My students will never get stumped by this question. It was about a duty owed, and it was about a skier, right? It says that an amateur skier causes an accident on a mountain. What duty of care will that amateur skier be held to? And it was an ordinarily prudent skier or an ordinarily prudent amateur skier. And I was like stumped. I was like, that seems like pretty tough, right? The rule of law, does anyone know the answer to that? Would it be the amateur skier? Are they held to the duty of care of an ordinarily prudent amateur skier or just an ordinarily prudent skier? Do they get a reduced duty because they're an amateur? Yeah, exactly. Just a regular skier. There's no reduction because they're an amateur. Now, what if they were an expert skier? Would they be held to the standard of care as an expert skier or as a regular skier? Would they get a higher standard? Yes, they would get a higher standard. See, that's the tough little test, right? And I remember getting tricked by that question. You don't get a reduced standard of care because you're no good at something. You put yourself on the mountain, you got to be held to the standard of care of a skier. But if you're an expert, you can't be like, oh, yeah, I won, the gold medal in the slalom in 2022, but like today I was just an ordinary skier. It's like, no, you're going to have that heightened duty based on your expertise, right? So some concepts about the duty owed, right? The breach is pretty obvious, right? Did they breach that duty? Did they deviate from the standard of care when considering an ordinarily prudent person under similarly situated circumstances, right? That's going to be the breach part. And then the causation, duty breach causation needs to be actual, the but for cause, right? Like if they didn't actually cause it, there was no, there's one question about like uh, a kid makes fun of his teacher, keeps doing like the 6'7" meme or something, and the teacher, quit and then a year later commits suicide. Can they, sue the kid for damages there? And the answer is probably no, right? They weren't the actual cause of it. Like she had, other issues going on and things like that. It's too, too remote, right? And then proximate cause is like the foreseeable plaintiff or the zone of danger, right? Was it foreseeable that this would happen, that this injury could occur, and or were they outside the zone of danger? They were too far removed from the negligent event to say that the causation occurred. Um, on the MBE, most injuries are foreseeable, right? It's foreseeable that if I'm a driver and I cause an accident and Susie breaks her leg, right? I'm responsible for her broken leg. Like that's, my friend James, he would love that case, right? I'm responsible for her broken leg. Now, what if 3 weeks later she's walking on crutches? And of course, in the NBA, there's bananas just like all over. It's like Mario Kart. There's a banana on the floor, and her crutch slips on the banana and causes her to break her arm. Am I going to be liable for her broken arm? Like, I didn't break her arm, I just broke her leg. But yes, because it's the domino effect. Her broken leg caused her to have crutches. It's foreseeable. Someone on crutches would slip on a banana, and therefore, liability would attach. Maybe the grocery store would also be liable, right, in some sort of contribution for the banana on the floor, but it wouldn't cut off my liability because it was foreseeable. And then damages, compensatory versus punitive damages. Punitive damages are to punish, therefore, wanton and gross negligence, and usually a limitation of how high in proportion we could receive punitive damages compared to compensatory damages. On the MBE, you're going to assume pure comparative fault, meaning that even if you're 90% at fault, you can recover for the other 10%, right? If there's a car crash and Tommy's 90% at fault, can Tommy sue? Yeah, Tommy can sue and recover 10%. And who can he recover the 10% from? On the MBE, you're going to assume joint and several liability. He can recover that 10% from any of the other parties that are liable, and then they would have to seek contribution from the others, right? So that's what you assume. You assume pure comparative fault and joint and several liability. But there could be a question that tells you this jurisdiction has a modified comparative fault statute or that it has um, contributory negligence, right? Modified means that if any party's over 50% at fault, they're barred from recovery. And contributory negligence, which is common law, standard, means that any amount of negligence operates as a bar to recovery. So assumption of risk would be a complete bar to recovery under a contributory negligence jurisdiction. If they don't tell you, it's pure comparative negligence. But if they do tell you, this follows common law principles of contribution, then you would assume it's contributory negligence. So that's pretty important. And also you assume joint and several liability unless they tell you, they've abolished joint and several liability or whatever the fact pattern may be. So it's really a reading comprehension test, but you gotta look into those factors. For negligence, there could be NIED, negligent infliction of emotional distress, negligent hiring, negligent supervision, negligent training. You're just looking for a deviation from the standard of care. Some key terms like res ipsa loquitur, the thing speaks for itself, means that like, if the pot was left on Tommy's balcony and it fell and hit Susie in the head, well, pots don't just fall off balconies in the absence of negligence, so Tommy's liable. It's his balcony, it's his pot. Now, what if there's 100 balconies and we don't know whose it fell off of? Can we sue them all jointly and severally? No, you have to prove some causation, right? So that's um, res ipsa loquitur. A thing speaks for itself. If it's the scalpel that the doctor used was under the exclusive control of the doctors and nurses and it was left in someone's body, then you could show that there's definitely res ipsa loquitur. A thing speaks for itself. Negligence per se is this concept that there's statutory negligence. There's a deviation from care as described by a statute. Speeding. If you go 80 miles per hour and cause an accident, well, you're negligent because this the um the speed limit was 65, you were going 90, you deviate from that standard of care. But it has to be the protected class and a design injury. Like if you park next to a fire hydrant and then someone side swipes your car, they can't sue you under that statute because you park next to the fire hydrant, because the purpose, the design of that statute is, to allow the firefighters to get to the hydrant so they can save people from fires, not to, you know, prevent you from getting sideswiped. So remember, for that negligence per se, it has to be the reason, the designed injury and the protected class for you to bring that negligent per se argument in. Besides the negligence torts, there's also the intentional torts, the assault, battery, trespass to land, trespass to shadows, conversion, IIED, intentional infliction of emotional distress, intentional interference of a business relationship, right? These are all the intentional torts. And then there's other torts like defamation or invasion of privacy torts or nuisance, right? Nuisance, typically what's tested is the concept that it's not a nuisance if you're unreasonably sensitive, abnormally sensitive. If you're nocturnal, you can't sue your next door neighbor because the kids are playing outside at 3 p.m. in the afternoon, and you like to sleep in the afternoon. You're abnormally sensitive, so it wouldn't be a claim that you could bring. For IIED, it's usually the concept they're looking for, the matching word we're looking for is outrageous behavior, right? It's outrageous, so it's IIED, intentional infliction of emotional distress. Trespass to shadows versus conversion. Conversion is total deprivation, right? Like you are going to have to pay the market value price for the property you damaged. Whereas trespass to shadows is just a temporary interference, or a small amount, something that's not going to be the total amount. Conversion, you're going to have to pay that total amount. And then trespass, yeah, that's, intrusion upon another's property. Um, a common defense to trespass would be privilege, right? Necessity. Like you can dock your boat on someone's dock if there's stormy seas, right? You could park your car on someone's driveway if there's a huge storm or something, right? Like that could potentially be a defense, is that privilege of necessity. And then assault and battery. So assault is when you place someone in apprehension of imminent offensive touching, right? Like you can't assault someone from behind who's not looking at you, right? Maybe criminally you could, attempted battery, but from a civil perspective, it's not assault if you're sleeping, right? If you're sleeping and someone tries to like slap you and scare you, that's not assault because you didn't apprehend it. Now, could it be battery? Well, yeah, if they touch you in an offensive manner, sure, it could be battery. Typically, assault and battery come together, but you could see, battery from behind is not assault, and a punch that doesn't land is assault, but not battery, right? Because you assaulted them, but you didn't actually make contact. Um, Remember, battery's a dignity tort, meaning that it doesn't matter if when Will Smith smacked the shit out of Chris Rock, maybe from what I saw, Chris Rock didn't even feel it, right? It's like, there's a little bug. That's definitely battery. Even though he might not have been injured by it, right? It didn't seem like he was very injured. I mean, emotionally, but like it's a dignity tort. That touching was offensive, so that would constitute battery in that sense. Um, so yeah, and then defamation. Defamation is dissemination of material to a third party that's injurious to another's reputation. They like to test the concept of a public plaintiff versus a private plaintiff. A private plaintiff needs to show negligence, whereas a public plaintiff needs to show actual malice, right? That they knew it was untruthful, or something malicious in that effect. So there's subtle differences between public defamation and private defamation. And there's also that concept of slander per se, where it's damages are presumed, right? If it's the mnemonic is club, crimes of moral turpitude, loathsome diseases, unchastity, a woman's chastity, or relating to a person's business, then they would all be instances where we would invoke uh, slander per se, right? So again, it's a introductory course, essentials course. That was pretty much my quick lecture on contracts and torts. I want to just share with y'all some of the cool stuff that we have. We'll probably do the Jeopardy next week, but for contracts and torts, we have these different PowerPoints that I go over a lot more in depth. when I do the actual course, but just kind of see some of the things that we saw. Assault and battery, right? Assault is placing someone in reasonable apprehension, and then battery, like I said, is that actual offensive conduct, right? This pretty good image. False imprisonment, I didn't really talk about, but that's when an act or mission resulting in restraint or confinement with intent and causation, and the shopkeeper's privilege. You can reasonably detain someone to figure out if they stole something, but then you got to let them go. If you you think Susie stole the dress, you put Susie in the back room and you figure out quickly she didn't steal the dress, you got to let her go. Once you keep her, confined after that, it does become uh, false imprisonment. IIED, like we said, abominably or outrageously, right? You're looking for that outrageous conduct that causes emotional distress. Trespass to land, right? It could be, walking onto someone's property or, throwing your trash on someone's property, right? And then we talk about trespass to shallows versus conversion. Conversion is the complete sufficient deprivation where you would be liable for the market value, whereas, you know, temporary interference would be trespass to shadows. Nuisance, you think of illegal activity, noise pollution, light pollution, water pollution, noxious odors, fences, constant barking, could be a private nuisance. But again, not if they're unreasonably sensitive. That's a commonly tested exception. Defenses to intentional torts, consent, self-defense, defense of another person, necessity. So for self-defense, right, for battery, it's intentional. Was the conduct intentional to constitute battery? But what if we say, yeah, but it was self-defense? Well, then we switch to a reasonable standard. Was it reasonable to think that self-defense was necessary? Not did that person actually objectively think that it was necessary, but subjectively, would a reasonable person think that self-defense was necessary? So the element of intent is needs to be proven for that tort of battery, but the reasonable standard is used when it comes to something like self-defense. We talked about negligence. We assume joint and several liability, and it's a pure comparative negligence assumption. Negligence per se, like I said, statutory negligence. Defamation. Truth is a complete defense to defamation, right? If you say, this bar prep company uses stolen materials and they do, right? That's not defamation. Not our company, but some of these other ones that kind of suck. And then you know, um, another point of defamation is you could be privileged by invitation. If you're invited, I get this all the time. Susie's applying for the bar. What do you think of Susie? And if I'm like, oh, well, she did X, Y, and Z, and then it wouldn't be defamation because I was invited to speak on my opinion about Susie. Products liability, definitely a tough subject. Remember that liability for strict liability, it could be, inherently dangerous activities, it could be wild animals, or perhaps a products liability case. And it's when the product is defective when it leaves the hands of the business or entity, right? Like if you're a component part manufacturer, let's say I manufacture tires and I make good tires and I send them off to the assembler, and then the assembler assembles a defective car and then ships it to the retailer and the retailer sells it. Who there is liable under a strict liability theory? Not me. I didn't do anything wrong. My tires were proper, but the assembler definitely they assembled a defective product, and the subsequent retailer because they were downstream of the defect. It was defective when it left their hands. So that's going to be the consideration with products liability is like you're not liable upstream of the defect, but anyone downstream of the defect can be held strictly liable for a products liability case. And then all these PowerPoints, these are things that come straight from like my cram guides. I have tons of these cram guides, but you can see like these are how the test is won and lost, right? From particular questions like a 13-year-old girl driving a motorboat recklessly will be held to the standard of care of an adult because she's operating a boat, right? It's an adult-like activity. And the more you can just go through these, cram guides and create your own, everything will become repetitive to you, and you'll really, be familiar with the fact pattern recognition. For contracts, we went over this pretty solidly, but we talked about UCC versus common law, mirror image at common law, and the UCC will have that bow the forms provision. That one right there is interesting about shipment of non-conforming goods. So if there's a prompt shipment contract, say I'll pay $500, $520 to anyone who ships me 10 red widgets, right? And Susie ships me 10 orange widgets. Well, what do we have there? We have an acceptance of the contract and a subsequent breach, right? Because you accepted by prompt delivery, but then you shipped non-conforming goods. The only exception to that would be if there's a notice of accommodation, which would be like, hey, Andrew, I saw you want a delivery of 10 red widgets. I sent you 10 orange widgets. Let me know if these will do, right? That would be a notice of accommodation. That is more of a counter offer, right? It's not a acceptance and a breach. It's a counter offer because it had that notice of accommodation. And then unilateral contracts are accepted by performance. And once performance has begun, they can't rescind the offer. It hasn't been necessarily accepted until performance is completed, but it does create a contract that cannot be rescinded. Like the bank says they'll pay $1,000 to anyone who waits in line and, signs up for this form. Well, Susie starts waiting in line. And then they say, oh, sorry, the offer's been terminated. You can't because she already began performance and therefore has started her acceptance. So that's something to think about with a unilateral contract. These are all the different defenses. We talked about a lot of them. Mistake is a heavily tested one, unilateral or mutual. If there's a mutual mistake, like I thought it was for a pony, you thought it was for a goat. All right, we just totally we're both reasonably mistaken here, and it's no fault of either party. Yeah, sure, we can rescind or reform the contract. Like it's neither party's fault. But if there's a unilateral mistake, right? Like you thought it was you made a clerical error and put $1,100, and I thought $1,100 was proper. You thought it was supposed to be 1,000, but you made a clerical error and it's reasonable. You're going to be bound to that mistake because it was unilateral, and a unilateral party will be bound to their mistake unless the non-mistaken party knew of the mistaken party's mistake and essentially took advantage of them. So these are some of the defenses to contract that are pretty important. We talked about damages, right? Like one other one that I didn't mention would be liquidated damages. Liquidated damages are contemplated in advance because they'd be too speculative in light of a breach, and they have to be reasonable and cannot operate as a penalty. So liquidated damages, think of like a construction contract where there's an electrician and a roofer. And we need the roof before we can do the electricity. So the roofer has in his contract, roof will be completed by March 1st. For every week that it's delayed, he will be liable for, $1,000. And that's a reasonable amount. Well, that'll be enforced as a liquidated damages clause because it was contemplated in advance. It's, agreed upon in the event of a breach. And then, yeah, in the event of a breach, we don't have time to go to court and figure out how much money you owe. We got this house to build. So, like, we'll enforce the liquidated damages clause. If it's not reasonable, or it operates as a penalty, meaning it's just punishing them and not really remedying the non-breaching party properly, it won't be enforceable, right? Um, and then we talked about liquidated damages here, anticipatory repudiation, parole evidence, installment contracts. So, every week you're going to deliver 50 widgets, right? It's an installment contract. Week 4, you only deliver 45 widgets. Well, you're going to have an opportunity to cure and deliver 55 widgets the subsequent week because that's one of the features of an installment contract. It has that opportunity to cure, unless it would be material, right? If it's like, we deliver the bread on Mondays, the bakery cooks them on Tuesdays, and that's a fact. And it's an installment contract. Well, if we deliver the bread on Monday, but it's short, we wouldn't be able to cure that on Wednesday because it's material. They bake on Tuesday. So it's got to be, something that isn't a material breach, but you will be able to cure. It's an exception to that perfect tender rule, right? Typically, you need perfect tender under the UCC, but installment contracts will often allow for an opportunity to cure if it's possible without, substantially impairing the contract. Um, and then, yeah, measuring damages. I mean, this is a formula, general expectation, which is loss in value plus other loss. So loss in value would be like expectation damages. Other loss would be consequential foreseeable damages, and then incidental damages, damages to recover for the breach. Maybe you had to, drive to a new interview and pay gas money. Well, that would be an incidental damage. And then minus cost avoided and loss avoided, right? So cost avoided meaning like mitigation, right? And then loss avoided maybe if you salvage and you sell to a salvage company or you make some money back, right? Like it really comes down to like your actual loss. That's how you're going to be remedied. And people have a lot of difficulty with these damages questions because it's math and lawyers don't like math. But I tend to like math. I love math, right? It's very black and white. The answer is the answer. So, the better you get at calculating these, they're not like hard math problems. It's just, you know, um, it's conceptual. And if you understand what you're trying to do, don't look at the breaching party. We don't care about them. Look at the non-breaching party and how are we going to make them whole again? And did they do all the mitigation that they were, required to do? We'll factor all that into play, but we're just going to make them whole again. We're not going to unjustly enrich them, but we're also not going to make it so that they have to suffer the burden of the breaching party's breach. They're the non-breaching party, and the goal is to make them whole. And then the last slide here is about third-party beneficiaries, right? Um, they can stand in the shoes of one of the parties and enforce the rights. And then I have compare the hospital patient getting sick from a breach of cleaning contract to the father being paid by his two children each month. I gave you that example, right? A and B agreed to pay father every month. Father's an intended beneficiary. The hospital patient getting sick means like the hospital has a contract with a cleaning company where, rooms have to be cleaned to a certain standard and then the patient gets sick because the rooms were not cleaned to a certain standard. Can that patient sue under that cleaning contract? The answer is no, because they're an incidental beneficiary, right? They're not the person who was contemplated to benefit from it. The contract was between the hospital and the cleaning company to keep the rooms clean. The patients are just incidental beneficiaries in that specific example. And then just like we did with torts, I typically end these PowerPoints with, the cram guide details, which are, straight from, different cram guides that I've made over the years or whatever it may be, and I just put them on the PowerPoint to just kind of reinforce that idea of like, you know, there's so many testable points when it comes to these subjects that you got to learn them all. And the only way to really learn them all is to do the practice questions. The outlines and the lectures, they're helpful, but there's only so much that they can cover, right? You really got to do the questions and learn from each one of them individually. So, like for here, free on board, the risk of loss passes to the buyer once the goods are aboard a common carrier, right? So, like A and B have a destination contract, right? Or a shipment contract. Typically, it's a shipment contract, free on board. Once it gets to the common carrier, the risk of loss passes. But if it's truly a destination contract, then they have to make sure that the goods are in good repair all the way until they arrive at their destination, right? So that's kind of the difference between a FOB shipment contract versus a destination contract that, signifies the destination city, and then the risk of loss wouldn't pass until there's actually been delivery. So yeah, a lot of um, details and different cram guide points here. Um, restitution when one party is unjustly enriched, the other party receives restitution to return the ill-gotten gains. And courts may supply a reasonable term when the term is missing from the contract, right? That would be like a UCC gap filler. I mean, a lot of these cram guide points only make sense when you've done the question and then you can visualize the question, you can visualize the rule of law, and you just turn this into like a memory bank. And it'll work, right? If you just do this and stick to it, you're gonna do fine on test day. But I can't stress enough that like it's a really, really hard test. And I've had a lot of students who've really struggled with the MBE where, they've studied for hours upon hours, but then I'll be like, all right, let's do some practice questions and they'll get a bunch of them wrong. And I'm like, well, you're not where you need to be. If you really want to guarantee that you could pass this test, I'd recommend getting our question bank or doing a commercial question bank and hammering away at those questions, even via repetition, until you're getting them all right and you understand why you're getting them all right and you can explain the concepts to others, right? I really do think this is a mastery test. Unfortunately, it's a detail-oriented test and not so much a minimum competency test. I don't really believe in that theory. Um, you know, the questions are tricky. There's a lot of trick questions, and you want to make sure that you're not just getting the right answer, but you're also getting the right explanation. Yes, because of this reasoning. So, read the questions very carefully. I recommend reading the call of the question first so you know what you're being tasked to answer, and then making sure you're truly answering that question. A lot of people get questions wrong, not because they don't know the law, but because, a reading comprehension error or a careless reading or some similar mistake like that. So let's see what our quote is from today. Oh, solid. I hated every minute of training, but I said, don't quit, suffer now, and live the rest of your life as a champion. I mean, the great Muhammad Ali, that's a solid quote. Nobody wants to be here. I'm included, right? This isn't my favorite activity, but this is what I do for a living. And y'all are rocking with me now. And you can just see like I didn't have any notes in front of me when I gave my lecture, and I have lecture videos where I do the same thing. I taught more classes than probably anyone in the history of the world when it comes to like this bar prep stuff. So, I've really mastered my craft, and I'm just trying to train y'all to be just like me, right? By the time the test comes around, you should know this stuff just as well as I do. Um, yeah, I really appreciate everyone for hanging out with me tonight. I know we went about 20 minutes over. That was because I wanted to make sure that we did the introductions at the beginning. And yeah, I really appreciate everyone. I'm super grateful for your presence and participation. And like I said, we will continue with the Essentials course on Thursday, a week from today. We're going to be doing the next two subjects, con law and real property. In the meantime, I encourage everyone to do the NCB diagnostic quiz, and then yeah, start, jumping into actual practice questions, contracts and torts, to go with the pace of the program. And then if you do my complete course starting in December, we're going to start all the way over from the beginning, and you'll have a nice head start. You had a question, Diego?
Yeah, I wanted to ask that for the mini quizzes we have in the classroom, do you want us to get those done for next week or save those toward the end?
Um, I'll be honest with everyone. I've been doing the essentials course now. I think this is like my fourth, fifth essentials course. Man, the homework ratio is very small. I think it's because people just can't accept that this has begun and it's time to get to work. So my expectations on your homework are not as high as they used to be, right? But I would get started on it. I know that Danny has like a week before you do contracts and torts, and you're supposed to be doing only the diagnostic this week. But I would recommend, since we just did contracts and torts, try to get a head start and do the NCB diagnostic and do those mini quizzes for contracts and torts. And it just helps me a lot to get an understanding of like where you're standing right now. If the test was tomorrow, how much, extra help you may need. I mean, I'm very transparent with my students. Like my business is chugging along right now. I could probably stop teaching and just let the ship sail, but I really try to do everything I can to help people pass. And I'm honest with people. If you do those practice quizzes and you get totally, crushed by them, I would probably tell you, hey, maybe you should consider one-on-one tutoring. Maybe you should, do more than you're doing right now or whatever it may be. So it's just a good way for us to get a diagnostic of where you stand today. But like, no matter what, I don't want anyone to get discouraged. We're gonna start clean from the beginning in December. This November course is really just get the wheels turning and get a head start on all the other students. But really great question. Anyone else have any other questions for me about anything? All right, amazing. I'm gonna stop today's recording.